What do you do if someone sues you? What do you need to know when you go to court? Welcome to this segment on defendants in civil litigation. Let us answer your questions. Understanding the hearing notification letter. When you receive a court date notification letter, what part should you pay special attention to? First, you should note the contact details of the court and the clerk in charge. Once you're at the courthouse, you'll give your case number to court personnel so they can check on your case. The cause of action refers to the type of civil litigation as characterized by the court on the basis of the facts. The plaintiff column tells you who your opponent is in your case. Conversely, the plaintiff can also find out who the defendant is by looking at this column. The time of arrival indicates the time the proceedings are scheduled to begin. Note the location of the proceedings, including the courtroom number, to avoid going to the wrong place on the day of the hearing. The type of session reveals what the court is prepared to do on the court date. The most common sessions are preparatory proceedings and oral arguments. The preparatory proceedings session confirms the claims of both parties and investigates the evidence relating to the case. The oral argument session is when both parties try to persuade the judge to rule in their favor, according to the results of the evidence investigation. The notes column will give details of anything you need to pay attention to during the court hearing. What should I do if I can't attend court on the designated date? You can appoint an agent. If your agent ad litem is not a lawyer, you must first be granted permission from the court. Or you should provide a valid reason for your absence. If I receive a hearing notification, do I have to attend court? When you receive notification of an oral argument session from the court, if you or your agent ad litem will be absent without a valid reason, and you don't dispute the claims, this is seen as you accepting the claims and facts as the plaintiff states them. The judge can then declare a judgment on the basis of the plaintiff's pleading. Beware that your absence without a valid reason will impact your rights and interests. In the first and second instances of civil litigation, it is not compulsory to hire a lawyer, so you can represent yourself in court. However, undertaking a lawsuit requires a certain level of legal knowledge, so if you do not understand the law, you can contact the Joint Service Center at any court for help, or hire a lawyer to represent you. A lawyer will allow proceedings to go more smoothly. Disputing a claim. When you receive the court date notification letter, you'll also receive a copy of the plaintiff's claims. If you don't agree with the plaintiff's claims and you want to dispute them, you should submit counterclaims to the court within the time frame specified on the court date notification letter and provide a copy to the plaintiff. How do I write a counterclaim pleading? You can visit our website and our AI customer service assistant can help you. Just enter a term in the search box. You'll find templates and examples to use as a reference. Your counterclaim pleading should include 1. Facts supporting your claims. 2. Evidence to back your counterclaims. 3. Aspects of the plaintiff's facts and evidence that you agree or disagree with. If you disagree, provide a reason. After completing your written pleading, you can mail it or submit it in person to the court. Preparing for court. The day you are set to appear in court arrives. If the court has agreed to remote proceedings, please refer to the Remote Court Proceedings Handbook in advance. For more information, you can scan the QR code in the top left corner. If you are attending court in person, remember your appearance should reflect your respect for the court. On that day, remember to bring your ROC ID card or other identification, your notification letter, and any other required documents indicated in the notification letter. If you wish to bring additional documents for the court to consider, remember to prepare extra copies for each plaintiff. Ideally, you should register your attendance at the court early, giving yourself time to find the courtroom. Please make use of public transportation when possible. Don't forget to log in a bit early if it's a remote proceeding. There are 2 ways to register your arrival at court: at the counter or the check-in kiosk. Then, wait for a court attendant to call you in. If it's not your turn yet, you can either stay outside in the waiting area or sit in the public gallery inside your appointed courtroom and listen to the current session. If the appointed time arrives and your case hasn't been called yet, the previous case may have gone over on time. Like hospital clinics, courts hear several cases every day, so please be patient. You can check the progress of the previous case on the court's website or on the LCD monitors outside the court. After entering the courtroom, please remain silent and be respectful. Court procedures and your rights. Private recordings of sound, images, or photographs are not permitted inside the courtroom. If required, you can apply for a CD recording from the court after proceedings are complete. Now I'll take you on a tour of the courtroom. At the front is the judge's bench. Below the judge are the court clerk and the court interpreter. In the center is the witness stand. The plaintiff and their agent ad litem are on the right. The defendant and their agent ad litem are on the left. Witnesses and other relevant persons are in the spectator gallery waiting to testify. When proceedings begin, the judge will allow you to speak, so please be patient. When the judge asks you for an explanation, you only need to state the important points. If the judge is unclear on any parts, they will ask you to expound on them. If you're worried you can't explain things well, you can submit a supplemental written pleading. Please respect the right of others to explain themselves. Do not interrupt them. If you want to counter, please raise your hand. You may speak again with the judge's permission. In court, the clerk will make a written record of the main points of the proceedings. Everyone will have a computer monitor to view this record. If you discover an error or misunderstanding in this record, you can report it immediately. The court will organize all the information from the proceedings and bind these documents in order in a case file. It contains records of what the judges, litigants, and witnesses said in every court hearing. The litigants can apply with the court to review the case file during the proceedings or apply for the case file on CD. After the court has undergone the necessary investigation of evidence and given both parties ample opportunity to make their case, if the judge thinks that the court has clarified everything, the required investigation, they will announce the conclusion of the oral arguments. If you have any evidence or material you wish to present to the court, you should do so before the judge announces the conclusion of oral arguments. Otherwise, in principle, you will not get another hearing in court, and the material you wish to present will not be considered. For cases that have concluded their oral arguments, the judge will subsequently announce the judgment day in court. On the judgment day, the judge will announce the judgment in court if any litigant attends. The court will send you a written judgment regardless of your attendance. Going to court is not as difficult as you might imagine, so let's protect our rights together.